Thank you.
Bring the applicant in, please. Yes, Mr. Walker.
Thank you. Before the break, Justice Weinberg raised with me some aspects of the High Court's references to the nature of such an appeal in Baden Clay. And I just wanted to draw to attention in 258 Commonwealth Law Reports 308 at 329 paragraph 65, which happens not coincidentally to be the paragraph where the Constitutional Tribunal reference is repeated. There is, by citation of M, an MFA, a continuance without qualification of the principles in M as those which govern the nature of such an appeal. We, for our part, do not point to any change in jurisprudence that affects the conduct of a case such as the present. The change, to which I don't need to return, having dealt with it before the break, the change is in the availability, now quite common rather than quite rare, of the same material with nearly the same or virtually the same advantage, so-called, by dint of recorded evidence. Could I return so as to complete what I wanted to say about the second incident? Binder 8, Table L. I wanted to draw to attention, by way of emphasis, the import of Mr. Connor's evidence. So, even if the procession was internal because of the weather, the Archbishop, my client, would nonetheless greet people, but undercover rather than outside, but still at the west door, which means, of course, that the procession would continue without him and the celebrating priest accompanying him. And Mr. Connor gave evidence not merely of a practice, but also evidence concerning the 23rd of February 1997. Now, the effect of the Archbishop being at the west door on the complainant's account of the Archbishop being among the choristers as the procession came to an end is impossible. They are almost as far apart in the cathedral premises, those 2 points, as you can be, and still be in the curtilage of the cathedral. There is, we're sure, no dispute between the parties. It'll be common ground that if he did stop at the west door, then it's really not realistically possible that he was amongst the choristers in the manner the complainant's account of the second incident would have it. Now, evidence from a witness called by the Crown to the effect that it was not realistically possible for the offending to have occurred as the complainant would have it was the hallmark, correctly with respect, identified in paragraph 27 of His Honour's pre-trial ruling on section 38 of such evidence being categorised as unfavourable and opening the way for leave to cross-examine. There was no leave sought with Mr Connor, and there was no challenge to his evidence. Could I draw to attention, please, in Table L, which I can amalgamate with Table M, to which I'm next coming, another matter relating to the plausibility, credibility, likelihood of the second incident occurring in accordance with the complainant's account. Your Honours will know from the material, and I trust after Your Honour's advantage of the view, that the location identified in the corridor for this violent attack is between the two sacristy doors, meaning in the relevant direction it's past the priest's sacristy and going, if you like, towards the Archbishop's sacristy. To disrobe, of course, the appropriate sacristy needs to be identified. The renovation of the cathedral was not trouble-free, obviously. The Archbishop's sacristy and its built-in furniture was shellacked over-enthusiastically so as to impede drawers from opening that should open, and had to be redone. There was further delay. The Archbishop's sacristy did not become available when, as it were, the rest of the cathedral became available. It is, we think, common ground by a combination of proof and agreed fact that the Archbishop, my client, was first back at the cathedral for Mass, I don't mean saying Mass, presiding at Mass, first back at the cathedral for Mass on the 23rd of February. There are agreed facts about earlier period in February when he was abroad. But the 23rd of February was when he was first back. And in our submission, it is clear from the material to which we've drawn attention in our Table L and M that the Archbishop's sacristy was simply not available, not open for robing, not being used for robing or disrobing on the 23rd of February. So it was the priest's sacristy that was being used for that purpose. What you will see in the Respondent's Table L, at their page 29, is references to evidence, including what is not said in certain witnesses' evidence, plainly intended to engender the notion that the Archbishop really was there and was in that position because that was a day when he was in a hurry to get to Maidstone and was on his way to the Archbishop's sacristy. He'd gone past the priest's sacristy because he was using the Archbishop's sacristy for disrobing. That's plainly what is being hinted at. But it is, for the reasons I've just pointed out, and by reason of the evidence to which we've given reference in our documents, Table L and M, just impossible to conceive of the Archbishop's sacristy being available on the 23rd of February. It was not. The significance perhaps more lies in this, that it's another demonstration of an understandable concern by the prosecution, including in this court, of trying to answer matters which tend to the high improbability of the offending as alleged. After all, if supposedly a rush to be at Maidstone meant that, contrary to the evidence of Mr. Connor, my client kept up with, stayed with the procession, hurried through to the sacristy, one has this extraordinary and shocking notion that though he is in a hurry to go off to an ecclesiastical appointment at Maidstone, he stops for this whirlwind of an attack. Now, leave aside that improbability, which of course is a perennial consideration in such a case. Simply looking at the movements in question, on the account of the complainant, it took place in a location where, for the Archbishop to be perpetrating this, he must have gone past the sacristy where he would have been headed for the rapid disrobing in order to get to Maidstone. Now, as your honours know, the theory falls apart for another reason as well. Maidstone did not require such a rush at all, as the informant made clear. The significance lies in our submission in an entirely proper appreciation by the Crown that these are the hallmarks not only of matters that give rise to reasonable doubt, but also of the impossibility of having seen these to be resolved by the so-called advantage of the jury. Could I ask your honours now, please?
Just before you move on, Mr. Walker, when you talk about the advantage of the jury, is one of the advantages the fact that it's 12 ordinary men and women who bring their own life experiences to the exercise of judging what the facts are?
No. I would submit that's not within an understanding of the advantage for this reason. There is not a legislated nor what I'll call common law self-deprecation by the judiciary that places the judiciary at a disadvantage in terms of the evaluation of criminal evidence or indeed of things of the world. With all the seriousness I can muster, I submit the bench is not unworldly, nor for that matter are people who are not judges or even not lawyers or even not practising lawyers. It is not the case that they have categorically some superiority of faculty in judging facts. Many people have, in terms of ordered fact-finding, rather suggested the contrary, if anything, but I don't need to go there. The advantage, I'm going to say traditionally because of the matters that Justice Weinberg has raised, the advantage traditionally has been what's sometimes been called the look, the sound and the smell of the room in which the trial is being conducted, the courtroom. There is nothing in the jurisprudence to suggest that there is an advantage by reason of the lay, in this state at least, the lay, legal lay nature of the jurors. And one can readily see why there couldn't be any, with respect, sensible jurisprudence about what I'll call their varied life experiences, because that's the whole point. Varied life experiences is so various that while you might end up with 12 chartered accountants, you probably won't, but you won't know what mix you do end up in any particular case, so no generalities or abstractions can be uttered about the virtue of a jury, either as a collection of individuals or as an assembly, so as to constitute that advantage. But, and it's a big but, the identification of a jury selected as it is in this state, that is, those who are eligible and those who are ineligible, unquestionably is an aspect of the reflection by Your Honours as appellate judges for the purposes of what I'm going to call the second question. But it simply doesn't fall, as the Chief Justice has asked me to consider, into the notion of advantage. But the second question doesn't get answered by Your Honours as if you were jurors. As judges, you consider with what you know about the so-called advantage, including nowadays, in a case like this, what you may doubt about the supposed advantage, whether there is something not available to you. That's the point about the great care and the so-called deference, not available to you, which would explain away the reasonable doubt which, ex hypothesi, you had felt. This is not a case in our submission which would be an appropriate one for the court to venture a view that nowadays advantage should also be considered to be comprised in consideration of who is ineligible to be on a jury, for example. The likely mix, it would be very dangerous to generalise as to likely mix for a start. And in particular, it would be quite wrong for the court, as it were, to self-deprecate with respect to your worldliness, your capacity for fact-finding. Table M, please, Your Honours. You will note that halfway down our table M, our page 35, we note what the Crown also argued, and we give a reference to the closing of the prosecution at 1393 to 1394. The Archbishop's secretary no longer out of action as it had been at the end of 96. That is simply wrong for the reasons I've earlier put. However, Your Honours will note that in Table M we also deal with the Maidstone notion. I don't need to develop that any more than we have in that table. It went away as well. The evidence by Monsignor Portelli concerning the non-availability continued on the 23rd of February of the Archbishop's sacristy was not challenged. And this is a theme that Your Honours will have seen in our tables, where evidence is not challenged. In our submission, it means that there's no rational basis for the rejection of evidence without a deal more being known about evidence. Where it is not challenged, as one knows from canons of fairness such as Brown and Dunn, it is, by and large, with exceptions that don't apply here, unreasonable to proceed on the basis that certain evidence was false. That is particularly so, bearing in mind a case run in the way this case was run, with extensive, remarkably extensive Section 38 leaves granted and the door open for further Section 38 applications on the bases to which we have referred.
The case was not put, though, on the basis that any of these Section 38 witnesses was lying.
That's right.
It was put on the basis that, having extracted from them concessions as to the possibility that something might have occurred, or that perhaps their memory may not have been perfect, matters of that kind, were those matters that had to be put by way of challenge under Brown and Dunn?
It's going to depend upon each piece of evidence. If somebody has said he remembers something, then a cross-examiner will need to challenge whether there is in fact a memory.
The witness concedes.
If you want to put doesn't remember.
If the witness concedes that although his evidence about normal practice
Yes.
is just that,
Yes.
he concedes that it's possible that this didn't occur invariably,
Yes.
Is there any need or obligation on the part of the prosecutor to explore further or challenge, instead of just going to the jury on the basis that that possibility puts an end to the impossibility theory, if I can put it that way?
Yes, and in the following way, and this is an important and thematic part of our case. It is not a challenge to much at all, though it does convey a kind of challenge to have somebody who has given evidence of a practice, as Your Honour with respect correctly puts it, that inherent in it being a practice and us being human, that it may have been departed from on occasions. Not much of a challenge, but it might be understood as a challenge to an unspoken notion that a practice has truly never been departed from. That's the first thing. However, the mere possibility, which is really inherent in the notion of a practice, that it may not be literally invariable, that is, has never been departed from in any circumstances, doesn't go very far at all to removing a reasonable doubt raised by the evidence of the usual practice, particularly when the evidence of the usual practice is not of a...
But I understand the point
is
you're
not
making.
of a mild kind, but of a very strong kind.
I understand the point you're making about the weight that would be accorded to that kind of concession, but I'm interested in knowing whether you say that it's actually part of an obligation on the prosecutor in a case like this to have challenged overtly, as it were, explored what was meant by possible, cross-examined uphill and down dale on extracting concessions about the width of that possibility. Is that necessary, or are you entitled to say this is unchallenged evidence and therefore must be accepted?
There are two categories of evidence, but one in which it will be necessary. And we've drawn to attention these witnesses in our tables. Those are where there is, and I've just shown you Mr Connor with respect to the West Door greeting on the 23rd of February, where they give evidence that the practice was followed on that day. Mind you, also accompanied by what I'll call self-corroborating evidence that can't remember the practice being departed from. In other words, it's such a usual practice that it is most unlikely it was departed from. Now, with a witness like that, if you want to go to the jury on the basis that on this day the practice was not followed, you will need to raise that with that witness, because it would be both unfair to the witness but also totally incomplete as forensic procedure for the Crown to say, without themselves calling evidence about not being at the door, that is evidence directed to I was at the door, he kept processing further, you would need to say, and on this occasion, the possibility that you have admitted in general came to pass, didn't it? He did not stop in accordance with a practice, which I accept as a practice. It didn't stop on this day. And the second category of witness is where you've got, after 22 years, evidence of practice, as Your Honours know, sometimes described in strong terms, such as invariable or backed up by centuries of canon law or corroborated by persons in a position to give that evidence, but nonetheless they don't have, after all this time, a specific memory of adherence to the practice on that day. One of the reasons why practice, particularly what I'll call ritualised practice evidence, is not only relevant but can be very weighty and is plainly a good foundation for raising a reasonable doubt, is that there are things that follow patterns in life. And in institutions such as a church, particularly with ritual of an ordered and prescribed kind, there is, as a matter of ordinary life experience, even greater likelihood of the practice not being departed from. And it won't do, really, for a Crown, as it were, to be supercilious about evidence of people who say, well, this is my practice, I can't remember it ever being departed from, so no, I don't remember this occasion 22 years ago, but I'm pretty sure I'd remember if the practice was departed from to the degree that you have proposed. For example, the Archbishop in full robes always being accompanied by somebody, with which Your Honours are familiar, important part of our case. I won't have time to dwell on the detail, it's all set out in the tables. That, in our submission, is evidence where, again, not so much by way of what might be called a Brown and Dunn challenge, but rather by way of obtaining evidence appropriate to resolve the reasonable doubt raised by the highly credible evidence of practice, of course the Crown will need to go further and say, and what do you say to the possibility that this was departed from on that day? What do you say to the possibility that you now simply can't remember the thing that you've just told us would have been memorable, namely a departure? Because without that, with respect, it is without foundation for the Crown to ask the jury to proceed on the basis by speculation, that though no one can say it was departed from on this day, it's a possibility unexcluded. Now, the unexcluded possibility plank in a Crown's attending to a putative reasonable doubt raised by material is, for the reasons I put before lunch and right at the heart of our case, a critical fallacy in their approach. We say perpetrated at trial and repeated here, and maybe most of this will be for reply. But in our submission, the mere possibility that never grapples with the particular occasion in question, but just left as that which is inherent in a practice, namely something being a practice doesn't guarantee that it always has happened and always will happen, that in our submission will never suffice. It is as if to say, accepting that the facts raise the material raises a reasonable doubt, the mere possibility that those facts are not such removes a reasonable doubt. That is to invert onus, it is to ignore standard, and it is, in our submission, a fundamental error of approach.
My sense, Mr Walker, is that the Crown case was put rather differently. It wasn't so much as removing a reasonable doubt, rather, well, at least as the Crown put it, you should believe the complainant. The question is, does the evidence, and I think you've called them the opportunity witnesses, raise a reasonable doubt? Whether it does or it doesn't, as I understood the argument, depends on whether this was an invariable practice. Because if it's not invariable, it may not necessarily raise a doubt. That's as I understand the argument.
It may, I think Your Honour may be a bit kind in reconstruction here, but perhaps we should wait for our friend. But no, the premise of the Section 38 was, which in part specifically focused on what I'm going to call practice evidence, was that it was unfavourable. That is, it tends to raise a reasonable doubt. And there is, used by the Crown, this notion of alibi for the west door greeting congregants rather than down the other end of the precincts. There is an acceptance that the material is such that, left in place, the Crown case cannot succeed. I mean, it is, as it were, beyond reasonable doubt.
That's not the Section 38 test.
No,
it's just adverse to your case.
No, I'm not suggesting it was. They're nearly quoting verbatim, and we've set it out in writing, the way in which that matter was put.
I see.
During argument. Of course, it's... No, you don't have to show this is fatal. No, of course not. What I'm saying is they said it was.
I see. Thank you.
Now, it's for those reasons, and with respect, they're correct on the facts of this case, that is material, that is fatal, because you can't be in two places at once. And in our submission, that's why one can truly characterised the way in which it was put below, and we think here as well, that so long as they can point to a mere possibility of the fact, that is the practice, not having been followed, and therefore that possibility having within it not followed on the particular day, that's the end of that material as giving rise to a reasonable doubt. Now, imagine, Your Honours, applying that to an alibi. Imagine saying, well, it's possible the wife is wrong about where the husband was, the accused husband was, and that possibility wipes out the alibi. Now, one only has to examine the way in which the court looked at alibi evidence in Palmer and SKA to see that that is not the way in which one proceeds as a matter of appellate method. That you can't say the complainant is accepted, therefore I don't have to explain why the alibi can't be right. That is exactly why we have the appellate jurisdiction, to avoid jury error of that kind. And I stress, unless you reverse the onus, the grounds for reasonable doubt have to be eliminated. You have to, in the jargon, destroy the alibi. Otherwise, there is reasonable doubt.
So bringing it back to practice, what you say is it's not enough to show that...
It's merely possible. You have to
show that it's to destroy it, you'd have to show it was a variable practice.
And it was varied on that occasion to such a degree of likelihood, which is way beyond merely possible, as to destroy what might be an alibi or lack of opportunity. And there was never what I'll call a chasing by the Crown. I crave forgiveness if I've been unfair in that general and universal statement, but I can't think of any occasion for the materials that we've examined for our tables that we put before this court where there was chasing in order to identify or designate the occasion in question as an occasion where there was a departure from practice. Bearing in mind, of course, that departure from practice would be memorable. Now, I'm trying to crush a few things together here in answer to the questions. It will, I think, abbreviate later reference to some of the table material. May I remind Your Honours of the evidence that was given when eventually the 15th and the 22nd of December could be identified as the only realistic candidates for the occasion said to be the first incident in the complainant's account, the 15th and the 22nd of December. And Your Honours will know that, and maybe I'm issuing a challenge to my friend here, unchallenged, there was evidence concerning the auspicious or special nature of those events. They were the first time the newly installed Archbishop had said solemn Mass at his cathedral on a Sunday. There were crowds. He, by contrast with his predecessor, wanted to meet congregants after Mass in the usual place for such things, if I can give evidence to the bar table in the Protestant tradition at least, outside the door which ecclesiastically is the west door, furthest from the altar. Now, I'm so sorry, Rona.
Oh, I was just going to ask you about the 22nd. So the 15th, first occasion.
It's talked about in the evidence as first occasions in the plural. I can't explain why they're yoked in that evidence, but they are. So the evidence is given, it's unchallenged, that these two were special because they're first occasions in the plural. They are, as Your Honour the Chief Justice, with respect, correctly points out, actually the first and second. And we live in a milieu where first is normally regarded as somehow more special than second. But that's not the point. The evidence was the first two were regarded as special. And for those reasons, there is recollection of greeting, not mere assertion of a practice. Now, with the practice of greeting, that which means that he couldn't be in the place where the complainant's account would have him, is different from the practice of an archbishop robed always being accompanied. The latter is centuries of canon law. The former is a preference of the new archbishop. And there is a lively dispute that Your Honours will see, or at least the remnants of it, in our tables. I don't have time to dwell on the detail, about whether this was a practice accepted by the Crown but not really inaugurated or at least developed or at least displayed, not sure which of those, until 1997. Therefore, lo and behold, in 1996, the force, which is conceded by this argument, the force of that practice obtaining in December for the 15th and the 22nd is dissipated, says the Crown. Now, I can just urge on Your Honours, given the time, that our writing shows that that practice was followed from the beginning of the Archbishop's tenure, but more to the point, there is distinct recollection of it on those days. And Your Honours will recall the striking matter of Mrs McGlone embarrassing her son. Archbishop to Mrs McGlone, you must be very proud of your son. I don't know about that. Mrs McGlone talking about her meeting with the Archbishop after Mass forever since.
And it being burnt into Mr McGlone's memory.
Yes, and Mr McGlone being described by the Crown as having narrated a really memorable occasion. In other words, there's no credibility attack. There is a belated reliability attack, which would post-date it away from the impossible to accommodate 15th and 22nd of December to sometime in 1997. But forensically done by a means which is, in our submission, out of court, because it's not put to Mr McGlone. He doesn't deal with that.
You're saying this was raised for the first time in closing address?
Exactly. This is speculation of a frank kind which cannot provide anything in the nature of an answer to the reasonable doubt surely raised by Mr McGlone. Now, true it is, Mr McGlone was referring to one of the two possible occasions, but it means as to one of the two possible occasions, it could not be so. It is, in our submission, an example of the kind of forensic disadvantage which, after all this time, and with respect to matters which at the time would not necessarily have been the subject of earnest gaze by people who would remember it forever, routine matters of ritual, for example, it showed that notwithstanding that disadvantage, we were able to point to material, not courtesy of the Crown, we had to extract it, we were able to point to material which gives rise to the piled up improbability of the complainant's account being correct. And then when you add the fact that, of course, we are still handicapped because of the necessary lack of specificity of recollection 22 years after the event. Was the practice always followed? I think so. Is it possible it wasn't? Well, yes. No chasing there. And what about on this occasion? Because we know from some of these witnesses that they say, no, it was followed on this occasion. And it's for those reasons in our submission that it really comes nowhere near what the Crown had to do, carrying its onus for attempted discharge from beginning to end of the trial. When these matters are raised by the facts, it is simply not good enough, comes nowhere near accomplishment of their task to point to this generalised, undifferentiated, unspecific possibility. A very long way of answering Justice Weinberg's question concerning the nature of challenge, but it is, in my presentation on behalf of my client, it is right at the heart of the inadequacy, we say, of the Crown case. Could I come now, please, to binder 4? And we are now on to the first incident. I've finished what I want to say about the second incident. They inform each other in the way I've already said, but I'm now moving to the first incident. And I have anticipated most of the subject matter of Table B, but not all, by my remarks in answering Justice Weinberg's question. May I draw to attention something I would like to correct, I think. In the first cell on our Table B, evidence of the complainant, you will see in the first and second line and in the second last line phrases which are in quotation marks. I'm bound to say as if they're quotations. I don't think they are, they're paraphrases.
So we should just cross them out then?
No, well, take the quotation marks out.
That's what I meant, not
yes.
the words.
Not the words, please. Yes, and I do apologise if I cause consternation for Your Honour's associates. The transcript references are those that we rely upon for those paraphrases. I don't want to dwell on the detail. I've captured, I hope, in what I've said in the last 10 minutes, the importance for our case of the alibi, the real alibi presented by being on the front steps after Mass on the 15th and the 22nd of December. Can I draw to attention what we submit is another frank speculation of a kind unworthy in light of the transcript? Your Honours, I've already told you, Your Honours already know, that issue was joined, as it were, about whether a practice accepted to be a practice, namely after Mass greeting the congregants, but the issue was joined about it was not a practice on the 15th and 22nd of December. Now, one difficulty with all of that is it doesn't seem to have been put to anybody. There seems to have been simply a speculation that, like all practices, it has to have a beginning, and maybe it's a gradual beginning. But that's all made up, in the sense that it doesn't derive any support in any of the evidence. And it's not even put to people. So there's a double aspect to this. There's no evidence to support it, and people who give evidence to the contrary of it and to the observance of the practice on these auspicious occasions are not even invited to comment on the possibility that they're wrong. It didn't happen on those occasions, even with the extra large congregations and the like. Now, Your Honours appreciate that the timing is as I opened this morning. I don't have time to dwell on it, but we're talking about minutes. In order for the offending to have occurred, as alleged by the complainant, it must happen really very soon after the end of Mass. And for functional purposes, that equates to the beginning of the procession. It doesn't necessarily equate to the beginning of the procession moving, but it does equate with the beginning of the procession forming up in order to move. So leaving aside niceties of that kind, end of Mass, procession, then, so the complainant's version go, breaking out of external procession at the point that Your Honours have had identified to you on the view, outside, they going their separate way, the procession continuing on, and then within a couple of minutes, the Archbishop walking in on them alone. Then 5 to 6 minutes of offending, and then on what I'll call the bizarrely unlikely stopwatch theory of the Crown, then it is possible for those who will be in and out of the sacristy, according to a practice that nobody doubts happens. It's not as if, as it were, the sacred vessels were left on the altar on this occasion and did not come back to the sacristy. No one suggests that. But there's the practice. We have an abundance of evidence by people involved in the practice that it occurred. It never didn't occur. The timing of it is described. Your Honours have seen the details in the tables in such a way that for the offending to have occurred, it must have, as it were, just scraped in. That's already reason to be very chary of its probability of ever having occurred. But that is supplying in our submission far too much credence even to the beginning of it, for the main reason that we have put, that you've seen developed in writing, that the Archbishop was nowhere near the sacristy within that 10 minutes. And when I say 10, I'm being generous by estimate. This is only a matter of estimation. And that's why you'll see records of the Crown accepting that if he was at the door in the usual way he was, then their case must fail. And that's a proper approach with respect. So that meant that the issue there was, had they proven beyond reasonable doubt the offending, including by destruction of the proposition that he did spend at the west door the time he usually spent, which was at least 10 minutes, likely more. And that's what, in our submission, was never done by the method that I've tried to describe. Before leaving Mr McGlone, could I remind you that he as well, as you will see on page 4 of our cell with respect to him of this table B, he as well was the subject, without having had the opportunity to deal with the suggestion. It was suggested to him that what he could remember was in 1997, just like the practice. And that, with respect, cannot be justified as something that could reasonably have been put to the jury. He was not asked any questions that would enable, for example, consideration of that theory by reference to details to be obtained by the prosecution from him about when he ceased serving Mass. It seems on the material, it's all in writing, it seems on the material that it wouldn't be safe to regard him as serving any Masses in 1997. But the problem with speculations of the kind that are bereft of evidentiary foundation is they don't come with dates. And so we come back to the idea that how are we meant to deal with the idea never put to Mr McGlone, who gives a recollection of 1996, how are we meant to deal with the idea that in fact that's all wrong and it must have happened in 1997? Or may have happened in 1987. Must is utterly unjustified, may is irrelevant because inadequate.
Was exception taken about that when it was put in final address?
I'm so sorry, Your Honour.
Was exception taken about that?
Well, contradiction was put.
But if as you're putting it, was improper...
An objection, no. No.
I mean, nothing much turns on it, but
it's not. It doesn't fill the gap in the evidence. That's
right. But you're making again an implicit misconduct contention.
Doesn't have to be misconduct.
No, I follow that.
It's an explanation for unreasonable reasoning.
If this was thought to be relevantly prejudicial to your client, it could have been objected to in the course of final address and withdrawn, couldn't it?
There were things of that kind.
Just
certainly
so.
At the first. Your Honour, the fact, yes is the answer. The fact that it wasn't goes nowhere in an unreasonable ground of appeal. We don't waive the requisite quality of a Crown case.
But I'm just trying to get the
sense
of what significance it was seen by those who were there as having.
The significance could be seen in the way in which emphasis was laid upon Mr McGlone's 1996 evidence in the defence submissions.
Yes.
So that it was significant. And the jury could have been in no doubt. And the jury, of course, had a general no speculation direction. And so putting those all together, yes, there was real significance. Here's what the evidence is. There's speculation, and you're told not to speculate. That in our submission is all that was necessary. And in any event, as I say, there's nothing in the nature of a waiver that can be put here. I need to go to 622.
I don't know how many more of these matters you're going to go through, Mr Walker, but I for one would like you to address at some point the robes and the significance of the robes, if you can. I'm sure you deal with that at some stage.
I will, Your Honour.
And also to add to the list, the brazenness of the location for each of the incidents.
Yes, Your Honour. Yes.
And the President's question before lunch, which I'm
Yes.
sure you haven't forgotten.
No, and I'm coming to it as well. An example of what I was referring to earlier, raising a possibility of departure from a practice but not relating it to the occasions in question, can be seen, as Your Honours will no doubt have read and witnessed, in Monsignor Portelli's evidence, picking it up at 583, at line 27, and continuing to 584, line 3, you see, as it were, what is not put. Then may I take you to 597. Your Honours have seen the exchange in writing about the reference to bugs in the system. At 597, lines 5 and 6, Monsignor Portelli refers to a number of bugs in the system that needed ironing out. He illustrates sound system and the height of a lectern. No questions about, and did it also include whether or not it was going to be the new custom, unlike the old Archbishop, for the new Archbishop to greet the congregants. Nothing like that was ever put. But the argument was put to the jury and is repeated here. That's a ground for saying that the new Archbishop's greeting of congregants after Mass didn't start till later by reason of some unexplained bug in the inauguration of such a custom needing to be ironed out. Nothing is advanced by way of an explanation as to how any bug of a kind that might affect a sound system, indeed probably always affects all sound systems, or a lectern, because the Archbishop is taller than his predecessor, nothing of that kind was proposed as to how on earth this would prevent a man who wants to meet congregants from doing just that. We're not talking about physical barriers to him doing so. We're not talking about any security problem. Nothing is ventured. Simply a speculation to the jury, repeated with respect, here, in our submission, a hallmark of a proper appreciation of the difficulty in resolving the reasonable doubt raised by the convincing evidence that this was an Archbishop who on these occasions did greet the congregants for a period rendering the offending impossible. And you will see on that very same page 597, I don't need to read it, you've read our references to it, from lines 20 over to on 598, line 6, the specific evidence that was not then challenged pursuant to section 38 already granted or to be sought with respect to that greeting of congregants occurring on those two occasions, which by then, in the issues joined between the parties, were the only two candidates for the first incident. Hence
Your
the
point
reference.
is that this reliance on the bugs proposition shouldn't be seen to have, well, leave aside the point that there was no evidentiary foundation for it. We end up back where you were, which is no better than a possibility
That's right.
of non-following of any given practice on any given day.
But a completely unspecific possibility.
Yes.
It doesn't even relate to a period. And he was Master of Ceremonies for more than a week.
Yes.
Can I remind you, not just the passage that I've just given you the reference to, at 6:22, lines 16 to 24, there is another passage of evidence that was susceptible to cross-examination pursuant to Section 38 leave, but never done. Never done. The availability of that leave, the unfavourable nature, ex hypothesi, of such material, coupled with the failure in any event to take a mere possibility further in order to relate it to events in question, combine in our submission rather to bolster than to diminish a reasonable doubt, and certainly comes nowhere near to removing it. I'd ask Your Honours please to go to Binder 5. I'll try to abbreviate the details for which we give citations to the transcript are all important in this section. Remembering how significant these first two archbishops' saying of Mass at his new cathedral were, there is obviously matter to be addressed by a prosecution with respect to evidence by Monsignor Portelli that on those two occasions he was with the Archbishop and he remained with him the entire time he was robed, in accordance with the practice, which is not just a habit, but in accordance with what I might call ritual rule, sanctioned by an expectation of invariable practice. Humans err, but the expectation is invariable practice. Now, that we submit is evidence in relation to which the Crown can point to nothing which detracted from it. And bearing in mind the Section 38 milieu to which I've referred, and bearing in mind the nature of this ritual expectation, one can only say that the failure to be able to point to material which discredits that recollection is, in our submission, highly significant. Highly significant because it shows a failure to remove a plank that the prosecution agreed constituted an answer in the nature of alibi. I don't want to take Your Honours to the passage, given the time, but particularly Your Honours will recall when you see it, the material at 614, 615. On our page 9 of the table, in the cell relating to Monsignor Portelli, we have dealt in detail with a matter that deserves a little notice here today. Understandably, there were attempts to deal with this evidence by Monsignor Portelli. The first really went nowhere and will not be persisted in, we're sure. He was off having a smoke. That goes. The second...
Withdrawn at the trial, wasn't it?
Exactly.
Yes.
It went up in smoke. So the second one had to do with not misbehaviour of that kind, or slackness of that kind, but rather performing one of the duties that he had explained, which was that if there was something in the afternoon that the Archbishop would be involved in, that books, sermons, whatever, would be in place, and that Monsignor Portelli would be away from the sacristy if that sort of thing had happened. He's talking here about habit, custom, practice, in order to check, 1 or 2 minutes away, in order to check the right books were there. Of course, no attempt is seriously made, except in a completely ineffectual way, to show any such afternoon engagement. The ineffectual way was to point to the routine evening mass scheduled, not for the Archbishop, in the evening, as if it were a pointer to Monsignor Portelli being away for that errand. But the 1 or 2 minutes for a start simply won't fit the time we know is necessary for the offending in question, and in any event it leaves out of account what we have drawn to attention in the cell for Mr. Potter, which makes it clear that such is the requirement for a robed Archbishop not to be unattended, that if one attendant were to leave, another would replace. And of course, with neither of those witnesses was there any attempt, by what I call chasing, to find out how you would relate possibilities of departure from that to any of the events in question.
There was a problem with Mr. Potter's evidence, was there not? However, he's obviously of advanced age. He had real difficulties with dates and a sequence of events and so forth.
There's no doubt about that, and it was dealt with in a specific, if I may say so, humane way at trial. It is not a problem. They were not difficulties or problems that in effect meant that his material, particularly in relation to ritual practices, was discredited or put forward as discredited. We called other witnesses, all of whom were available to be challenged with possible departure from this ritual rule having occurred on these days. As Your Honours know, their evidence is crystal clear that it was a practice of real importance, and for those reasons the significance by way of telling deficiency in challenge to them about their memories of the practice goes a long way to ensuring that the reasonable doubt raised could not be dispelled by consideration of the complainant's evidence.
When you said you called witnesses, I take it you mean you nominated
I'm so sorry.
them to the prosecution to be called?
The Crown called all of them.
Yes.
We questioned witnesses is what I really mean, because as Your Honours will know, the cross-examination elicited in a deal of these materials considerable material beyond what had been adduced in chief. I don't necessarily complain about that. Where I do complain about it, I've written it down. But that, Your Honour is right, that was my
Because I think the defence called no evidence.
No evidence. We certainly, as it were, suggested people whom the Crown should call, and very properly they did.
Yes.
Binder 6, may it please your honours. A pattern has been set by which I can shorten what I want to say about it. Your honours will appreciate that this in particular concerns the circumstance about what I might call the orderliness of a procession. The issue was in effect joined between the witnesses, really all but the complainant, who gave evidence of order and decorum outside in public view as the public face of the cathedral. This was important because the double file processing with the hierarchy of adults and children was such that two robed choir boys ducking out of the procession is in the nature of things something that somebody behind would have noticed. And we elicited evidence from witnesses called by the prosecution which uniformly spoke at the time of Mr Finnegan's supervision, spoke of the strictness with which this was followed. Now, in a sense, this is practice evidence as well, but it's very weighty practice evidence, and it lends real force to the proposition that emerged in their evidence. No, they'd never seen anything like this happen. It's a bit like soldiers in full uniform leaving a parade ground. Well, now,
can I just say this, having read both the accounts given of Mr Finnegan's supervision and his own evidence, he didn't come across in evidence as quite as ferocious as others had portrayed him as being.
that's probably a matter of self-perception, Your Honour.
No, he acknowledged that his role was to supervise, and yes, we endeavoured to keep discipline, but it seemed to me that he, unsurprisingly, had a healthy appreciation of the realities of herding schoolboys.
They're not cats.
No,
These are choir boys.
No, they are. Anyway, it was just reading before one read Mr Finnegan himself, it sounded like he was an extraordinarily strict disciplinarian. His own account didn't quite match his reputation.
Well, he didn't own up to being Captain Bligh, but he was proud of the order that he preserved and confident of his capacity to have detected such flagrant departure from it. That's my summary of his evidence.
Indeed, and I think I'm right in saying that he returned to the choir after some years and then left again quite quickly because he thought standards had fallen badly.
Another piece of self-perception, no doubt, Your Honour. Now, Your Honours, it's convenient if I use Mr Finnegan for the purposes of a thematic observation here as well. Mr Finnegan and others had used the fact that the public, including tourists who found this charming, fascinating, quaint, depends on one's view, at least striking, and photogenic, that was used in the accounts given by the persons to whom we've drawn attention in this table to explain why there was decorum and order and dignity. Mr Finnegan was one of those. That evidence was not undermined by anything the Crown suggested, but in address it is suggested that he was distracted, or might have been distracted, it must only be might have been distracted, a possibility that wouldn't avail anyhow. He might have been distracted because of tourists photographing and the like. Now that in our submission is a really good example of that not providing a reasonable basis for the dispelling of the reasonable doubt as to whether the boys, based on the extreme unlikelihood of the boys breaking away undetected, where Mr Finnegan had actually pointed to the public view, including with their cameras, as a reason why there would have been the orderliness.
Wasn't it more significant, though, or able to be viewed by the jury as more significant than on his own evidence? Mr Finnegan went from the rear of the procession to the front in order to be at the door when the choir boys arrived so that he could see them in.
Yes, that's leaving only 30 to 40 pairs of eyes behind the boys.
Oh, just so. But
yes,
you were
yes.
focusing
Oh,
on
yes.
him, and
Oh, yes.
I read his evidence. I hadn't appreciated until I read it that he said so clearly, yes, I was at the back,
And Your
I
Honour,
went to make sure I was there by the time they got to the door. That
Yes.
creates different uncertainty about his vantage point, it seemed to me.
maybe, but again, we're in danger of reversing an onus.
No, we're just
They-
talking about what the evidence was.
No, Your Honour, I'm sorry, I'm jumping ahead. I'm accepting what Your Honour says. It's 397 and 405 that Your Honour's talking about. It doesn't enable one to say that he was not in a position at the relevant time to have seen boys ducking off. It doesn't say that at all.
A great deal depends, Mr Walker, upon exactly the point at which the boys
Exactly.
were sort of nicked off.
Exactly,
As
but
to whether it was before they got to the tunnel or in the tunnel or well before they got in the tunnel.
exactly, Your Honour. But these are uncertainties, respect, which do not bolster the Crown case. It works the other way round. Because that is an uncertainty that leaves open the possibility that Mr Finnegan was level with these boys when they ducked off. Precisely because their relative movements, vis-a-vis each other, cannot be known.
And would you say the same in relation to, he marked on one of the maps the 2 spots, and he said it was between those 2 spots, somewhere around about when the procession got to these positions, that I'd leave and move to the front. Is your response to that the same as to Justice Weinberg's
Yes, it is. But
observation?
I refer to other pairs of eyes. Your Honours will recall Mr Rodney Deering, and we've given the references to his relevant evidence on our page 17 in the cell for him, commencing with the words Deering explicitly said. And those are matters which in our submission stand quite regardless of where by then Mr Finnegan had reached in his going from the back to the front.
Can I just ask you this as a matter of logic, really? There is, I assume, a necessary relationship between the degree of uncertainty and the strength of the impossibility argument. For example, if there were evidence that a person had been in New Zealand on the day when she was alleged to have done something, it would have been demonstrably impossible for that to have occurred.
Yes?
We're not in a setting of that kind, though you've made an alibi argument, which of course we understand, but it goes back to this debate about possibilities.
Yes?
And I suppose it doesn't matter for your argument whether it's impossible or highly improbable.
That's right.
That's sufficient. That was sufficient to
leave,
oblige the jury to have a doubt.
to leave. For it
Pardon?
having been raised, for it to be left. Yes is the answer.
Yes, thank you.
Yes. Your Honours, I'm going to do table F very quickly by saying it does speak for itself. It's one of these other directions ones, literally, because it's from now inside at the organ console. Binder 7, table F. I don't want to spend any further time on it.
I think we're actually well familiar with this particular point.
Quite, Your Honour.
It might be better to go to
That's why
more substance.
I'm going to move off it to note that you'll find in the same binder 7, table G, the references to the choir rehearsals about which I was asked this morning. I don't want to add anything further to the way in which we emphasise the significance of that for the supposed aftermath of the offending, which in our submission is really so unlikely as not to be a realistic possibility of having occurred on these occasions, and therefore leaving a reasonable doubt as to whether they occurred at all. Another different direction point, part of the aftermath, Your Honours will find in Binder 7, Table H. It's the rejoining the choir point, and in our submission the same things follow, and it contributes to the accumulation of extreme improbability of the matter having occurred with an aftermath as given in the complainant's account. In Binder 8, we come to the question of robes. That's Table I. The language of the complainant's account is moving the robes to the side. The evidence about and of constituted by the robes is in our submission at odds with that as a possibility fairly described by those words. The nature of the robes, meaning that whatever moving to one side may mean, if, as it does, it conveys basically lateral movement, it would not expose any part of the body. And there was not evidence about a visually strikingly different imagined scenario whereby the relevant components of the robing were lifted up, which as a matter of English is not moving to one side, and raises an entirely different image, and of course is being done allegedly by a person who is using at least one, and I think on the Crown case really, two hands during at least aspects of the offending. We in particular had, as you Honours might understand, the evidence of the man responsible for the robing, Monsignor Portelli, which at 593 particularly lines 14 on 593 to line 2 on 594, in answer to questions by the Crown, made it clear that the nature of the robing and its fastening was such that you just don't go to the toilet. And hence the answer to a critical question, could it be lifted up? Now, why is that critical? This is in the Crown questioning. Because it means that an ordinary understanding of colloquial English, pushing it aside, won't fit. Now, it's no real part of our case, or even any case in such an appeal, to be pedantic about ranges of meaning of ordinary English. But giving fair weight to what is and is not conveyed in circumstances where there really are things that are not possible in question is proper. And that's why the Crown moves to asking, as a relevant proposition, could it be lifted up? It's because it needed to be.
That had already been addressed, hadn't it, by the complainant when he
Yes.
modified his account and
Yes.
said he wasn't certain whether it was moved
Yes.
apart or
Oh,
aside.
no,
or
quite
whether it was
so.
lifted up.
Quite so, which is why it's a relevant inquiry by the Crown. And the answer is, well, you'd have to put it somewhere while you're occupied. Where would you put it? In other words, continuing the theme, well, you just don't. And there is no material, least of all in the complainant's evidence, which, as Justice Weinberg has noted, or in relation to those parts that Justice Weinberg has noted, that's part of what we call the unstable or shifting aspect, which involves discrepancies and inconsistencies in the complainant's account or versions of his account. We're going to address them, as I said earlier, compendiously given the time, in our table N, to which I probably won't have time to take you. But it is attempted in that table to gather together from the various topics matters focusing on what I'll call significant, discrediting changes in version. That last change, that the in relation to what I call the manoeuvrability of the robes, is of course a change that plainly is an attempt to make the facts fit. And that in our submission is the very opposite of the kind of consideration which a jury could reasonably use to dispel the reasonable doubt raised by the effective impossibility, the lack of realistic possibility of the offending having occurred with these robes as it was said. Your Honours will recall that the nature of the complainant's evidence included the to and fro, back and forth, for example, about whether there were full robes, which is connected with whether the Archbishop was saying as opposed to presiding at Mass. That too, of course, he comes back to not only 1996, but yes, he was saying Mass, full robes. But there are passages to which we've drawn attention where he essays a suggestion that maybe it was not so. Maybe he was not saying it, maybe he didn't have full robes. That again is the hallmark of material in the complainant's evidence that could not do anything to dispel the reasonable doubt raised by these matters to the contrary.
Mr Walker, if you come back to the robes and the manoeuvrability, the chasubble's like a very large cape.
Yes.
And then the alb is underneath with other vestments as well.
Yes.
To get to the alb without disrobing, couldn't you move the chasuble to the side?
No, but the alb has no opening.
I know, that's what I'm saying. The chasuble being a big, like, cape, you could move the chasuble to the side, it would still leave the elb there,
You've got,
which is held firmly around the waist with the cincture, which is
that's right,
tied in
that's right,
quite a few different knots with the stole going around the neck and underneath the cincture.
that's right. But it's really the nature of the alb, not the chasuble. It's really the nature of the alb with its cincture that makes the pushing to one side, moving to one side, just not possible. Leaving only.
I understand why you would say that moving the elb to one side isn't possible. I'm not sure that that is true of the chasuble.
But taking the chasuble off altogether doesn't expose the body.
No, I understand that.
I know Your Honour does, I'm sorry. I may not be following properly, but in our submission...
Well, the initial evidence was moved the robes to one side.
Oh, I'm sorry, yes. If that means the chasuble, then it doesn't get to what the account of the offending involves, which is exposure of the body upon that movement of robes. That's what I mean.
Thank
So
you.
even if it could be understood as, because it is in a sense, though Your Honours have seen them, it's not all that straightforward, but it is easier to accommodate language of moving to one side with the chasuble than it is with the orb. It's impossible with the orb, but not so straightforward with the chasuble because of its nature and the way it hangs, etc. But yes, that I suppose might explain why those words were used of what is called, I think, an over-robe. But it doesn't explain at all that which would be still in place. And if anything, again, it shows what might be called a literally superficial view of matters by the complainant, who said he didn't know what was underneath the robes, and perhaps he didn't know what all the components of the robes were. He had never robed the Archbishop. So, if anything, again, that use of language, if one supposes, and this would be, I think, a speculation, if one supposes that was explicable by reference to the particular nature of the chasuble, then again, that does nothing to dispel the reasonable doubt raised by the nature of the alb. If anything, it may excite a concern about what I will call concoction. But it certainly doesn't tell in the other direction.
Mr Walker, just before we leave this, when the complainant was being cross-examined about this, and that was an occasion on which it was put to him that he'd invented something, transcript 347, to solve a problem that he appreciated, his answer was something like, well, the now applicant could and did push aside his robes, and went on to say, quote, I have no distinct recollection of the exact hand movements. Do you want to say anything about that? In other words, he was giving evidence in cross-examination of no distinct recollection of hand movements with respect to the robes, as I read it.
Yes, well, that is not evidence, obviously, which describes
No,
that which
on the
the nature
contrary,
of the...
it's a saying, well, I'm not sure that I really recall with any distinctness what the hands were doing.
I think Your Honours know what my answer is. It is, again, thematic. A, after the time, and B, given the nature of what he is there talking about, C, that conduces in our favour, should have at trial,
Yes.
and does here. Part of the purpose of Table N, which I commend to Your Honours in this particular regard, is that it shows the sequence of the unfolding of that evidence, and that's a sequence which in our submission does no credit to the complainant.
Yes, thank you.
May I ask Your Honours please to go to Binder 5, Table D. The one point we want to identify in address for this rather important aspect of the critical timing can be picked up by going to the way in which critical timing was closed by the Crown. We've extracted it on page 12 of our table, but you will find it at 1385 in the transcript of the closing. And we've quoted, and I stress, it was put thus: the offending was 5 to 6 minutes. That equates with the 5 to 6 minutes that Potter spoke about respecting the privacy of kneeling parishioners before he starts ferrying items to the sacristies. Again, it fits, it's not inconsistent. Now, it's to be recalled that the 5 to 6 minutes Mr. Crown was there referring to as the offending doesn't start at the end of Mass, because there is a period enough for them to find their illicit way to the sacristy, to go into the sacristy with no one else there, to rummage around, to find the wine, to swig, and then it being 1 or 2 minutes after they'd come in, supposedly the Archbishop comes in alone. And Mr. Crown estimated, in a way that I would not presume to criticise, the necessary estimates that produces the 5 to 6 minutes that you then see referred to in the submission. But the 5 to 6 minutes is obviously not immediately after the end of the Mass, because there's got to be time for the procession to go down the aisle, out the west door, down the outside, and then at the point Your Honours have had identified the alleged breaking away from the procession, then further time for the two boys supposedly to reach the sacristy, then further time, 1 or 2 minutes they say, it's said, before, after their rummaging and swigging, the Archbishop is said to come in. And you can see in that address that I've drawn to attention the notion being advanced that this is the same period, not just coincidentally a period different in time but of the same length, but it is the same period as the period which, on the basis of Mr. Potter's evidence and corroborated by Mr. Connor, as to what I call complementary activities, was what became known in argument as an interval of decorum, or an interval whereas the articles and implements and items of sacred dedication for use in the Mass would not be removed while there were congregants engaged in what amounts to private devotion at that place. And the Crown case depends upon that providing an interval for the 5 to 6 minutes offending. But because that 5 to 6 minutes offending, as we know assuredly, does not commence when mass finishes, on the evidence that we've drawn to attention, and issue is joined in the writing here. I don't know whether it is continued as issue, but we submit that it's clear on the evidence that that interval of decorum starts when mass finishes, that's when the congregants come for this private devotion. So while the procession is on, this interval of decorum is in course. It's in course. Now, I'm not suggesting there are clocks, but there are descriptions that are not just inherently credible, they're not challenged. What is in contest is, we think, a matter of entirely speculative argument. I shouldn't say I think. We submit, as we read the material marshalled in support of it, it can only be speculation. It delays unaccountably, in a way that witnesses were not called to explain or invited to explain, it delays the onset of a period which functionally and ritually most obviously commences at the end of Mass.
But it is again a matter of ineradicable uncertainty, is it not? In other words, the account given is perfectly plausible, that is to say, that there would be an interval of this kind for worshippers to spend time in private devotion. Necessarily, how long that took on any given day is a matter of uncertainty.
Exactly, Your Honour, but again my answer is the same, and that is an uncertainty which, after this period, in accordance with forensic disadvantage warning and proper understanding of the onus of proof, can only tell in our favour, should have at trial and should hear.
I'm not sure that that's right, though, and that's the point I was trying to raise with you before. It seems to me, with respect, that the argument for impossibility logically loses its force pro tanto as uncertainty grows.
No, that reverses an onus, Your Honour.
No, with great respect, I'm not talking about onus. You were then and are now advancing positive arguments about impossibility. It wasn't your case to prove, we know that.
It sufficed to raise a reasonable doubt.
Your point is, and you've confirmed it several times with me, the evidence established such high improbability, verging on impossibility, that there must have been a doubt. I'm just raising with you, for your assistance, the notion that the greater uncertainty which attends what might have happened on a particular day, the less forceful the argument from impossibility becomes. That must be true logically, mustn't it?
No, I want to challenge that. And it is because of onus and standard. As follows. The evidence that Your Honour has referred to, Your Honour calls it a positive case, but it is a contention by us, where we don't have to put any case at all, it is not said to have been false or incorrect as to what I might call its lineaments. There was such an interval, these activities needed to occur, they involve people going in and out of the sacristy. So all of that is accepted. The timing is indeed critical. The Crown accepts that. It can be seen from the way in which they ran the case from beginning to end. This is not a case where the timing has what might be called appreciable margins of error, or in programming terms, lots of generous float. It's not. It's unbelievably tight, and I mean that, unbelievably tight. And so, all we have to do at trial or here is to show that it was unreasonable to consider eliminated the reasonable doubt constituted by the, I'll use a neutral expression, difficulty of supposing 5 to 6 minutes of offending timed from the end of Mass, that is not beginning at the end of Mass, but timing some time after the end of Mass, where there would not be people coming in and out. So that's when, with great respect, in answer to the President, we put exactly the opposite of what Your Honour asked me to consider. With the uncertainty of time and also the fact that these are not time-recorded activities, there's no bell to be rung for the beginning or end of the interval of decorum, for example. Those lead to, I think Your Honour the President used the expression ineradicable uncertainty after 22 years, multiplied or magnified or rendered even less capable of being explored. That is a circumstance that means that the reasonable response of a jury would be to say, I cannot eliminate as a possibility, that there would be servers in and out of this room before the offending is said to have started and certainly while it was afoot. And that's the proper approach of a reasonable juror faced with this material. He or she would know that this is material that places the impossible, namely other people in the room, at the time of the alleged offending. Pressed by the Crown, I'm now doing this as a hypothetical, Your Honours appreciate, pressed by the Crown, but with the uncertainties, it's possible that this 5 to 6 minutes just fits in the way we argue. To which the answer by the defence, and with respect by a reasonable juror, is, but that possibility doesn't eliminate the opposite possibility to which this evidence also gives rise.
It's unfortunate in some ways that the case was pitched at the level of impossibility.
Quite so.
That term was used repeatedly.
Quite so.
One understands rhetorically why that may have been done.
Quite so.
It's quite misleading in lots of ways, it seems to me.
Your Honour, what matters conceptually is what I've been putting. The unexcluded possibility is what matters. What Your Honour has expressed a stricture upon does include the ambition of an advocate who presses the jury with the evidence that doesn't merely raise an unexcluded possibility, but goes so much further, not necessary for victory, to show a positive impossibility of the Crown case.
The risk of running it that way is that the jury, faced with competing arguments, answers the wrong question. They answer the question, was it possible? And
which would be unreasonable.
We convict.
Which would be unreasonable. But yes, I understand what Your Honour is saying. I think it's probably not fair to attribute that to the way this case was run in terms of the address.
I know the way the case was run, and I've seen how the argument was put, but it does seem to me, in hindsight, that the use of the term impossible on slides, for example, impossible, there were lots of things that one might have said were inherently improbable or unlikely, but they were elevated at various points to the level of individual impossibility rather than global impossibility.
Your Honour will appreciate that both sides embraced what is, after all, a commonplace of alibi reasoning, that if X be true, then it is impossible for the offending to take place as it occurred. And I think, with respect, that is a way in which the risk that Your Honour has adumbrated may have emerged without being, as it were, invited by either side.
Mr. Richter decided that he would not press for alibi. It was agreed that the term wouldn't be used by His Honour in the charge, and that, with respect, seems to me to have been very wise.
Yes, I used the word imitating the way the Crown had put it, Your Honour. Yeah. But it is that the alleged offender was in a different place at the time necessary to make out the Crown case.
In closing addresses, the way the case was put by the defence was one of impossibility, various levels of impossibility, if I can put it that way, if there is such a thing, and the Crown's response was, this was entirely possible, this was entirely possible, this was entirely possible, going to particular pieces of evidence which allowed that conclusion to be reached.
Yes.
In a case where it might fairly be said there are a number of negatives that have to be forensically disproved.
Yes.
I think your client in his record of interview himself raised the question of how he goes about, or how one can go about,
That's right.
disproving a negative or proving a negative.
Particularly when there is not, as it were, a definitively narrated sequence of events with dates, etc. And I've already said enough about the 23rd of February. Your Honour, the phrase improbable, not realistic, possible, or indeed impossible is one that Your Honours will recall from His Honour's charge to the jury in summarising what Mr Richter said, and that's at 1595 lines 21 to 23.
Well, that was correct and impeccable. I noticed, however, that the slide, or the first of the slides that were put up for the jury to see, the very first one used the term impossible in an unqualified sense. Again, for rhetorical purposes, one would have thought.
Yes, Your Honour, and one way of saying that there cannot be a proper conviction is to say that there has been proved in either the Crown case or the defence case, that is, the evidence taken as a whole, there has been proved a matter which renders the offending impossible. If there were conviction in the face of that argument, and if the appellate court agreed that the material in question, if accepted, would
taken as a whole.
I'm talking about all the evidence as a whole, but there's only going to be specified material said to raise a reasonable doubt of a particular kind. Here, that the alleged offender was somewhere else, or there were other people at the site that was said to be occupied only by the offender and the victims. Those are matters which in our submission are available for an unreasonable appeal ground by pointing to the way in which a reasonable doubt is raised by reference to this material, and someone in my position arguing that it could never dispel, that is, remove that reasonable doubt, simply to show it was possible the material giving rise to it was not true, because that would always carry with it the possibility that it was true. And that is reasoning which in our submission lowers the standard, or worse, reverses the onus. And
although the jury were told in clear and impeccable terms they were not to reason in that way.
I agree, with great respect, Your Honour, both with the fact and the characterisation. Yes. Impeccable directions, as Your Honours appreciate, it provides no immunity from an unreasonable ground of appeal. I was asked before the break about paragraph 48 of our friend's written case. It's said in that paragraph in the third and fourth lines that the priest's sacristy was an area in which the complainant could not recall having either seen, either before or after this event. Your Honour sees that. At 357, the matter emerges somewhat differently of the transcript.
He accepted, didn't he, that he'd been taken on a tour and accepted that he would have seen the priest's sacristy?
I can't put it that high, and I won't. And you were shown the sacristies. I have no recollection of that. No.
But I accept that.
Do you dispute it? No.
No, I understand.
So it's not as strong as Your Honour says, but in our submission, it is of course impossible for us, given the nature of a complainant in such a trial and the protections for a complainant, it is practically bordering on the impossible after 22 years for us to research the peregrinations of a choir boy or somebody thereafter, that is, after being a choir boy. And the onus is never on us to explain the means by which that kind of knowledge could be got. It's not the kind of case where only if there had been offending as alleged could this be known. We know that from the fact that these were premises in the near vicinity to which he carried on activities as a choir boy. We know they are premises to which, on his account, he would ask the jury to believe he could have illicit access. Now, we also know that he doesn't dispute that he may have been shown the sacristies. It's for those reasons in our submission that paragraph 48 is not what might be called a killer point at all.
Can I ask you this though? It's rather the other point mentioned in paragraph 48, which it's not whether he'd been in the priest's sacristy. It said, as I read it, that this is the bottom of page 19. Critically, the applicant was in fact, and quite irregularly as things turned out, required to use the priest's sacristy rather than the archbishop's sacristy, where he would ordinarily have returned after Mass. The complainant could not possibly have known of this irregularity unless he saw the applicant in that room after Mass. As I understand the point, he and I assume when he first gives an account of this, he identifies it as having occurred in that room, the priest's sacristy rather than the archbishop's sacristy, and as I understand what's said, he couldn't have known.
But there's no evidence to support he could not have known.
Well, maybe that's the answer. But
that is a...
It was an irregularity, as the evidence suggested, because of the shellacking to which you referred before, that unusually the Archbishop was having to change in the priest's sacristy.
This Archbishop had never changed in the Archbishop's sacristy as Archbishop.
Well, I follow that. But the point made is that this is a piece of information about that irregular use of the priest's sacristy by the Archbishop, of which the complainant could not have known if he hadn't been there.
No, I understand the argument is could not have known unless the offending had occurred as he narrated. That's said to be the force of the point against us.
Well, for example, if he invented it, you'd assume he would have put it in the Archbishop's sacristy.
No, indeed.
He would have assumed, wouldn't he, that that's where the Archbishop...
No. This is all speculation. The inference is that that which was openly being practiced, that is the Archbishop's sacristy being fixed up, was known, not unknown. There was no establishment by any evidence that this was a person whose position in the hierarchy was such that there is no way he could have known that the work was being done, and it's not hugger-mugger work, the work was being done, and that everyone was robing in the priest's sacristy. So in our submission, that is a speculative
So it's a false
argument.
premise that he couldn't have known. Indeed, there was nothing to show that he couldn't have.
Your Honours, the last point I want to address on ground one is in answer to the Chief Justice's question concerning what might be dubbed the brazenness of the alleged conduct, and that includes on both occasions. They are, I think, though different incidents, they are indifferent as to, I think, the fairness of that word being applied to it. Your Honours will gather from what we've both written and I have said that in our submission the first, not last, but the first response is in accordance with a long understanding when terrible things are alleged against people, in particular of understood good character, that there is an inherent improbability. Now, that is so far from being enough to secure acquittal at trial or on appeal that I need hardly dwell on it. But it is of its nature something that the prosecution needs to overcome. One of the reasons why there are directions against prejudice, why there are directions against stereotyping, and why there are directions against paying attention to speculation on social media or in the press, is of course to ensure that in accordance with their oaths, the juries will attend to the evidence about this person rather than make generalisations about men, persons in authority, persons in ecclesiastical authority, persons who are Roman Catholic, etc., etc., etc. So that there is no legitimate manner, rather only those manners which are proscribed by the oath and by the warnings. There is no legitimate manner by which brazenness can be attributed as a quality of the alleged conduct tending to render it more likely than not that it truly happened.
Quite the contrary.
And quite the contrary is our point.
Yes.
We accept that it is not for us a complete answer, and we never put it so. It was part of a quiver of material which is to be added to Your Honour's appreciation of whatever accumulation we have persuaded you might be seen of the matters that lead to a raised and left reasonable doubt.
It's probably worth saying, and I'm sure you know this, that appeals of this kind over the last decade or so, from time to time raise this issue. That is to say,
Yes.
it's so improbable, and convictions have been recorded and upheld on appeal where the conduct was, by any standard, brazen or
Yes.
involved the taking of great risk of discovery. And of course Hughes in the High Court is an example of someone whose convictions were upheld where his risky behaviour was persistent.
Yes.
I'm only saying that because that wouldn't be known to the jury, but it is well, perhaps it's it's an unexpected aspect of some forms or some occasions on which offending of this kind takes place.
But in order to avoid circularity of reasoning, that
Tells
is-
us nothing about this case.
No, that's what I was saying. Yes. Now, Your Honours, Ms. Shan.
Sorry, there was one more question. You accept, I take it, that assessing that amongst other factors was well within the jury's capability?
Assessing brazenness, Your Honour?
Yes. Well, I think it was called by your predecessor
Yes. Yes.
in final address the madman
Yes.
argument.
Yes
In
is
other
the
words, you
answer.
would be mad to do this, person in his position in these circumstances. Evaluating that was well within the jury's
It was
competence.
their duty to do so, and they were directed to do so.
No, it's a slightly different point. Clearly it was, but there may be some topics where you'd say, well, that's not something of which they would have had experience or be in a position to judge. It's really just to test the notion that judging how much that conduces to improbability
I know
or impossibility
quite.
well within the jury's competence.
And that's one of the reasons why you don't find, as it were, a table for it.
Thank you.
Yes, Ms Shand.
Thank you, Your Honours. I will, I hope, take 5 minutes and we'll still be on track to finish at 15:15. The point in ground 2 is quite simple. In the 21st century, an accused person should not be deprived of using 21st century modes of communicating their argument. And contrary to what His Honour found, that is what this was, an argument. It was not to be played, press play, watch. It was to be introduced, it was to be narrated and explained where there were variations. The input was accountable along the side, and there would have been time, due to the pausing that was explained to His Honour, for the jury to well understand and evaluate what went into the particular argument. But importantly and critically, in this trial, and perhaps we're at the end of a day where Your Honours may feel this, we're talking here in the first episode about a period of 10 to 15 minutes. But there were weeks and weeks of evidence about what happened in that period of time.
And you say it's very hard for a jury to synthesise that evidence, well, for any of us,
That's right.
to keep it in our head, let alone get a combined picture of it.
Yes. And the reason...
The problem with it, as I see it, so you can address it, is that you say it's an argument. Yes, it certainly is. It's got, in the graphic, a whole bunch of people in the priest's sacristy at the same time as the two choristers, the complainant and the other boy. There's no point showing that to the jury. That's your argument. Similarly, it's got the priest, the Archbishop, standing for quite a considerable time on the front steps. If he's standing for that period of time, there's no point showing that to the jury either. This is all simply a graphic picture of what you say would have had to be the case if these allegations had any substance to them at all. I just don't see the point of it.
The point of it, Your Honour, is, as the President picked up on, is that the Crown went to the jury saying the narrative is simple, frame by frame, because really their narrative involved three people being alone. And what we said was...
You put 10 others in there as well.
Yes, but in order to counter the claim by the prosecution that 5 to 6 minutes starts here, not there, these people would be off there, you can remove this person over there, you can just not mention this group or that group. In order to counter that, critically counter that, in order to defend someone accused of absolutely abominable crimes, we wanted to say to the jury, you cannot disappear these people and you can't ignore their evidence. And yes, we said that verbally, and Mr. Richter said it very ably, but it is requiring the jury to take sequential, verbally delivered pieces of argument and then to order them in their minds against each other, to evaluate then what we said against a very simple and, we say, incomplete narrative that was presented by the prosecution. We wanted to show what they did in closing, narrating frame by frame, did not match the evidence and was doing an incredible disservice to the whole of the evidence that the jury were required to grapple with. So this is something that no suggestion was made would be overly repetitive, that it was not said you are wasting time by repeating, The critique by His Honour was, this is evidence. There, in our submission, could have been no danger that the jury would have thought it as such, in light of how it was to be presented. It was an argument to assist a technology-addicted, modern drawing of 12 people from ordinary life who spend all day, every day, in their tablets, on their phones, not necessarily, because we don't know anything about them. We don't know their English proficiency, we don't know their educational background, we don't know whether they have any familiarity with the task that we were asking them to do. Sit and listen, and now reorder it all.
Your argument hinges on it not being treated as evidence. So it's argument, but there's the risk of it being treated as evidence by the jury. You say that's not a real risk. Am I right in understanding you to say it's not a real risk because there was going to be an explanation to go with it?
An explanation that it wasn't to be played from start to finish, it was to be introduced, it was to be stopped, to explain the input, and also to identify with a laser pointer, and this was all explained to His Honour, where there were divergences. So that it was very clear this was sourced from the material that was before the jury at the trial. This was not a new thing, this was a response to the verbal frame-by-frame narrative that was presented by the prosecution in closing, to say you must have a doubt about that narrative because it's not supported by the evidence.
It was a representation, you say, of the evidence?
Yes, and
or a representation of how you were submitting the evidence should be viewed?
that's right.
It's not quite the same thing.
No,
but
it was our argument of the evidence, and as we say and have taken care in the binder which has been prepared, far more grounded in the whole of the evidence than the narrative that was verbally presented in those simplistic terms.
So what was going to be said about the graphic that showed the priest's sacristy with the two boys, with the Archbishop and with a dozen other persons present? What was going to be said about that?
That the
There
time...
would have been a dozen other people present, perhaps?
that
How is that grounded in evidence?
that the two servers who gave evidence, McGlone and Connor, said every time, invariably, and we know Connor was there on these dates because his diary says so, we walked in the procession, we returned in the procession, and thereafter we did this. And that involved us, along with the 6 to 8 other altar servers, moving in and out of that room. So what that representation of the argument depicted was the return of the procession, and that on the complainant's account, having detached from the very same procession, these two parties head-on clashed in that room. That was something just never grappled with by the prosecution. In fact, that evidence of McGlone and Connor was just not referred to.
Ms. Jan, I suppose the question that arises for me is whether the exclusion of the animation in any way inhibited the defence from making the points which you would have made with the aid of the animation. And perhaps I can explain, having read the final address, which is very thorough indeed, the defence final address, very thorough indeed, I wouldn't have had a sense that any of the matters sought to be elicited from the evidence for the defence had been shortchanged in any relevant sense. In other words, all of the points, and you went second, of course, so you could point out whatever had been misrepresented by the prosecutor. So that's rather a different point. Assume you're right, His Honour was wrong, he should have let you in. What difference did it make?
We don't know what difference it
I
made.
follow that, but
That we don't know, because we couldn't ask them, whether the jury understood the force of the argument that we put verbally, sequentially, verbally, in a mode which is not conducive to a 21st century pool of people drawn from the street.
But it is, as we know, the mode subject to welcome moves towards the provision of written material to juries. It's the mode by which juries have always had to, been asked to, assumed to digest and understand evidence, isn't it?
It is, but the fact that we are in this trial, we attempted to do something new, should not be a point against us.
No, and with respect, that's not, I think, what any of us is suggesting. It's more to ask whether we should have any concern that your ability to identify both a view of the evidence, which you would have asked the jury to take where relevant, and to respond to deficiencies in the Crown's summary, whether the lack of this modern aid to comprehension in any relevant way prevented you doing that.
It did prevent that, Your Honour. This is quite a unique case in relation to the amount of evidence, talking about something from 22 years ago in such a confined period of time, where we have a plan. We know they're all in that precinct, and we have evidence of the ritual that was undertaken in the 10 to 15 minutes. So the difficulty in turning sequential information or sequential arguments of the evidence into that parallel, moving all together at the same time, is manifest here in a way that I don't know of another case that replicates that. It's not the case that this form of presenting an argument would occasion a substantial miscarriage of justice in all cases, or even many or most. But in this case, we say it does, because there is a possibility that the jury did not understand the force of our argument in relation to opportunity, and the degree to which, contrary to the prosecution case, that it all fits, it just doesn't and did not fit.
Can you point to any specific error or other error in His Honour's ruling in which he prevented you from playing this animation to the jury?
No, His Honour, the fundamental error was to view it as evidence rather than argument, and that
It was a mischaracterisation.
it was. And in His Honour's ruling, that appears the decisive feature.
Was there a risk that if it was the only animation of its kind, it would appear to have an authority, that is to say, this is the distillation of everything you've heard? In other words, that it would be seen as more authoritative than an argument should be seen as being?
If just played, perhaps, not with the appropriate information and the directions by His Honour about
how to
argument.
treat it.
Closing addresses are but argument, and we presume the jury follow directions.
Thank you.
The court pleases.
Your Honours, given the time, all I want to do with ground 3 is this. Your Honours have read the written case about it, which is short and I hope to the point. Can I just remind you, however, of the statutory setting? Section 210 of the Criminal Procedure Act stipulates that a trial commences when the accused pleads not guilty on arraignment in the presence of the jury panel in accordance with Section 217, to which of course I will come. Subsection 2 of Section 210 contemplates the possibility of a jury panel being split into 2 or more parts under subsection 35, that is Section 30, subsection 5 of the Juries Act, to which I shall also come. And when that is true, the trial commences when the accused pleads not guilty on arraignment in the presence of the first part of the jury panel that is present in court. Commencement of trial has the significance, not merely that those words obviously show something not commenced can't finish, but also in section 211, Your Honours know there are time limits, which given the terms of section 247 may turn out to be final. So these are framing the capacity to carry out the administration of justice. Section 217 requires, in a case that encompasses ours, that if an accused has not pleaded guilty to all of the charges on an indictment, the accused must be arraigned in the presence of the jury panel, or if a jury panel is split into two or more parts under subsection 5 of section 30 of the Juries Act, the first part of the jury panel that is present in court, and a jury for the trial must be impanelled from that jury panel. And Your Honours know about the progress from roll to pool to panel to jury. And the presence of a jury is, as Your Honours know, something which includes, if one goes to the Juries Act, in section 31, what might be called a final check, that those who are eligible and not ineligible and have been called for service, rather than somebody who's drifted in from the corridor, as is not unknown, are the people who make up the panel, section 31 of the Juries Act. Section 30, subsection 5, which has been added, as Your Honours know, it's not old, it's new. The proper officer, the associate, told to do that which needs to be done, may split the panel into two or more parts if he or she considers that it's not practicable for the whole panel to be present in the court at the one time, or that it's expedient to do so for any other reason. Put that together with 210, 217, and it's clear that that is a process that must include some members of the panel in the same room as the accused for arraignment.
You say that the failure to do that goes to the root of the trial.
Yes.
And the failure to take objection to it matters not.
It's extremely unfortunate, but it matters not to the cogency of the point. I'm afraid so, yes, Your Honour. That is our answer. May it please the Court.
Thank you, Mr Walker. Could the applicant please be taken from the court? Adjourn the court, please, till 9:30 tomorrow.
All stands, please. This honourable court stands adjourned until 9:30.